you know that you have something you will be here later by everyone, because we normally publish these videos. So thank you so much, Damien. Thank you so much, Sam, for being here, and thank you so much to all of you who have found this hour and a half to be with us today. The topic we chose for this new Innovation in Law Studies Alliance webinar is legal standardization. What does it mean, and why is it relevant to the future of law? And today we have two great speakers. Let me introduce you a few words about them. So Damien is a legal technologist, a lawyer, speaker, and writer, and at present he is the vice president at Fastcase, and he has joined us from Washington, United States. Thank you, Damien.
Good to be here.
And Sam is at the moment in the UK. He is the director of vendor relations at Rain Court, and previously he used to be the director of innovation at the Scottish law firm Barnes Paul. Thank you, Sam, for being with us today.
Great. Hi, everyone.
Okay. Well, the way we are going to have this webinar is first. We will pose both speakers 5 questions that we have previously prepared, and they will be answering one after the other. And then we will start an open debate where you, the audience, can take the microphone, put the video on, and ask anything or comment anything you want to add to what our speakers have said. So let's start with our first question. Damien, what do we mean with standardization when applied to the legal field? What does it mean?
In our discussions between Sam, you, and me before this call, I think there are 3 areas of standardization. One is being able to say what is a thing. For example, what is a merger agreement? That is a metadata. So a merger agreement and a force majeure clause. Agreeing that there is a thing called metadata, the force majeure clause and the merger agreement, that is a metadata standardization. In addition, there is a content standardization. So that is what is the standard force majeure clause in this type of agreement. So not that we just called the thing as metadata, but exactly what is the content of it. That's number 2. And number 3 is process standardization. How are documents created? How is advice given? That kind of process, in addition to the metadata, what is the thing called, and the content. So I think amongst those 3, to be able to standardize across the industry, saying, let's agree with what the things are, let's agree with how the things are expressed, and let's also agree on how the things are processed through the system. But I'd be interested in Sam's thoughts on any of those things.
Yeah, certainly. So I certainly agree with all of that. And from my own perspective on standardization starts with what are the users of legal services trying to actually achieve? So once you picture what the outcome is, the desired outcome, whether that's a contract, an agreement in place, or maybe a litigation or dispute being resolved, once you identify the outcome, thinking about the steps along that path, thinking about everything that has to happen, be agreed or be established, thinking about which of those steps don't need to be bespoke or specific to your situation. How many of them could be standardized? How many of them could be something that we all agree what it is and how it works? So you can focus your energy and attention on the parts of the process or the dispute that genuinely require a bespoke approach. So for me, as well as what Damien was saying, standardization is also about the journey, it's also about the process and what you do along the way as a user of legal services or a provider of legal services to get to those outcomes without reinventing the wheel.
Indeed, and I want to wholeheartedly agree with what Sam just said. And yeah, the not reinventing the wheel is something that the legal industry has struggled with for many years, that we famously have reinvented the wheel and have many billable hours to show for that. So I would say that, yes, the idea, the overarching idea is standardization makes us more efficient, which is better for humanity.
Is it all about efficiency, or maybe also about legal security about the legal industry being able to work together with the developer industry, maybe being able to cope with the challenges that are derived from a globalized and growing globalized world. What do you think?
I'll take that one first, if that's okay. So thinking about why do we bother? So what is the purpose of standardization? For me, there's actually quite a lot of different approaches, as you were just saying. We've got ideas around speed, certainly. So speed of adoption, speed of resolution of problems, and also access to legal services in general. The more standardized and the less opaque and the less bespoke legal services become, the more accessible they should be to a broader global audience. And there's also a lot of work being done just now around using standardization to break through conventional processes that just make adoption of tech in legal service just so painfully slow. In my previous career before working at Rain & Court, I was the person at that law firm whose job it was to introduce new technology to the firm. And I was finding routinely any change worth making took a year, 18 months, painfully slow pace of change. And the desire to change was there. The business cases were there. A big part of what was holding you up is having to take this bespoke approach again and again and again of everything you were trying to do, and the opportunities there to reuse prior learning or to reuse prior standards were very limited. So for me, the big reason why we do this is mostly about speed, to an extent about cost, because things should be cheaper when you keep the standardization high. But also, as you mentioned there, Maria, security is also a big part of it as well. Being confident that we are approaching technology and change in law in a way that is familiar and understood. And so when we're doing our compulsory due diligence on InfoSec, for example, not having to worry about a different approach being taken in the product every time, getting familiar with a standard approach makes it easier to evaluate, easier to risk assess, and kind of faster to adopt. So I would say for me, it's mostly about speed, then about cost, and potentially about security as well.
And I would agree with those things. I would add another is quality. If you standardize, you're able to connect like with like and be able to say, here is the best practices and the things that are on the long tail of things that are less frequently adopted, perhaps are not best practices. So I would add quality as an additional factor. A last factor I would say on my side would be interoperability. That is having all the vendors be able to agree that a merger agreement is a thing. So if I'm a law firm, I can query all of my vendors saying, send me all of your merger agreements or send me all of your motions to dismiss, and then having a uniform response to those. So that interoperability, having everyone agree, OK, here's our identifier for motion to dismiss, to be able to get a uniform response from Thomson Reuters, from Lexis, from Docket Alarm, from Rain & Court, from iManage, from NetDocuments. Everyone could be able to call a motion to dismiss the same thing. That interoperability is also important.
Yeah, I absolutely agree with that. A common problem when we are adopting technology in legal services is the products could be sophisticated and cutting edge and very innovative, but if it is siloed, if it is stuck inside its own space with no interoperability at all or limited functionality, that just gums up the works of change and it becomes a useful tool that you can't fit. I think of it sometimes like if you have different manufacturing standards and perhaps your bolts and screws of different diameters, trying to put them together becomes functionally impossible. No matter how good the bolt and how good the screw might be, if they can't fit together, you have nothing. So as Damien's just describing, if we can find a way to encourage vendors and developers of applications to agree on certain standards, particularly in taxonomies like Damien's describing, you open up tremendous possibilities for data to flow back and forth between different applications that without that agreed standardization, it's just going to be a nightmare full of little bespoke interpretive tools and adapters in between everything, which is not all sustainable.
Indeed. And, the financial industry is a good one to look at. To be able to interoperate, the banks need to be able to say, OK, let's agree with what kind of accounts can be transferred to what other accounts. Here's a standard for account numbers. Here's a standard for the amount. So that within the financial industry, that standard is called FIBO, F-I-B-O. And we're actually working with one of the founders of FIBO to be able to work with SALI, the Standards Alliance for the Legal Industry, SALI, to be able to help us with our taxonomy ontology to work in a similar way that the financial industry works together. So if you think about financial industry needs to transfer data to and from each other, the legal industry needs to transfer data to and from each other. Standards are the way to do that.
Yeah, one final point I wanted to mention as well is sometimes when I speak to students in particular about what has changed in legal services versus what hasn't changed, many things have become easier. But one of the things that, in my opinion, has actually become harder for consumers legal services is changing lawyers. And Damien's example there is fantastic because you can change a bank very, very easily because they all have the same standards. You can move your checking account, your savings account very easily from one to the other. And 20 years ago, moving your business from one law firm to a second law firm was also very easy. You physically collected the paper file and you took it with you and gave it to the new lawyer, and that's how you transferred your legal services. But as digitization has replaced that process, moving your business, your legal interest from law firm A to law firm B is surprisingly difficult because that data may not necessarily have the same standardization, the same structure as the other law firm. And that has a strange irony about it that it's a very anti-consumer position where it's become somehow more difficult to exercise your rights to change who your legal advisors are. And standardization, much as Damon was saying in the legal industry, that's necessary for that process to become as smooth and as consumer friendly as it really should be.
That's right. I would agree 100%. And if you think about the manufacturing world, Apple is a walled garden, right? Apple does not play well with standards, and there is a lock-in effect that people who are in Apple tend to stay in Apple because you really can't interoperate as easily with that data. So I guess I wonder if the legal industry, that is the legal providers, might think that's a feature, not a bug, right? That I can lock in my clients and keep them with me, so because it's really hard to transfer. I would say on this call, I would wager are not just law firms and law providers, but also clients, in-house legal counsel, and also academics who are teaching things. I would say that maybe there's maybe a discussion to be had amongst those three to say, is that lock-in, that kind of Apple lock-in walled garden effect, is that desirable from a societal standpoint? That's thing number one. And thing number two is even the law firms have many different vendors. That is, you might have 2, 3, 4, 5 different vendors. That interoperability is beneficial to the law firm if you can use the Sally API to run a query to vendor number one, and then use that if you decide I don't like vendor one anymore, I want to go to vendor two. If both vendors are using the Sally API, you can essentially just change the endpoint and very easily switch to vendor number two, which you like even better. And then 2 years later, switch to vendor number three. So anyway, law firms are the beneficiaries of this standard interoperability. So while they might think, I want to lock in my clients, they would very much like to be able to jump from vendor to vendor with the standard taxonomy. So there's very, what Sam said is absolutely right. And we should, I think the world and computing history favors open interoperability more than walled gardens.
Yeah, it's super interesting what you're saying, but I was thinking of how many times I hear lawyers saying, like, my knowledge cannot be standardized, and unique. It is impossible to standardize what I know. So, Sam, you were saying, well, in the past, lawyers used to reflect their work in one paper and would just move it. But the truth is that most lawyers are working the same way, and it's not the paper, it is their head and what they know and the know-how on how to do things. And that's knowledge management, and still not so many law firms do have a system to handle knowledge in a proper way. And you were saying, like, yeah, there are many advantages. It's quality, yes, it's cost, but cost maybe means that I make less money because when things are standardized, maybe it is less justified that I'm charging you a certain amount of money. So is there not a contradiction between the traditional way law firms have made their money, have raised their money, or lawyers have raised their money and justify their existence with standardization? Is there not a contradiction there in itself?
Potentially, yes. So when we were working with clients, with customers, you had to treat every client as if their requirements were unique. And in some cases they were, but it's not their whole requirements that's unique. to give you an example, if we were doing, say, trust and estates planning for a high net worth individual, there would be a lot of consistency between clients in terms of what they were trying to achieve, but the individual details of their estates and their wishes would be different. So it's not the case that you could standardize the entire process from start to finish. However, you could standardize a considerable amount of that process. And for me, the value in that is where the lawyer then applies their time. So if the lawyer is able to take out even as little as 20%, 30% of the process and standardize it, they're able to then take that time that's been saved and apply it to the remainder of the situation, which is genuinely bespoke. And in my experience so far, lawyers very much like to spend less time writing and less time drafting and more time discussing, advising, negotiating the soft skills that are a massive part of what we do as a profession. So I don't think there is an inherent contradiction as such. It's more about reevaluating where the lawyer adds value to that relationship and recognizing that some parts that could be standardized, potentially automated, probably should be to result in overall better client service.
I would agree 100% with that. And before I was at Fastcase, I spent a couple of years at Thomson Reuters, and I would speak with lawyers to be able to say, tell me about your practice. And almost to a lawyer, every lawyer would say, oh, I have a snowflake of a practice that cannot be replicated. One of those lawyers that I spoke with said, who said, I have a snowflake of practice, you cannot processize that. I said, how many matters do you go through in a particular month? And he said, about 200. So whether that lawyer knew that or not, he has a practice to be able to, and he has a standard to be able to process that many. There can't be 200 snowflakes per month. There's commonalities amongst those. And so I think people that think that their practices are unique just haven't taken the time to be able to say, how are all of these things the same? Or how are many of these things the same? Jason Barnwell is in-house counsel for Microsoft, and he is an engineer that has turned lawyer. And he said between engineering and lawyering, as an engineer, he said, engineers generally say, how are these things similar? And do it this way. Lawyers, in contrast, generally say, how is my thing different? And so he said, that lawyers need to think about as engineers a bit more to say, how are the things that I'm doing similar, right? Yes, there are, idiosyncrasies for particular things, but let's think of commonalities across all of my things or across many of my things and put those metadata tags on those commonalities. And then once you build out the commonalities and figure out the differences, which maybe are rare, then you're getting towards standardization to be able to take the knowledge in your head and pass it along to your associates. Pass it along to the next generation of the partners that you're going on next, because now you've tagged up all of the similarities and you can be able to put knowledge next to those similarities. For this type of motion in front of this judge in this jurisdiction, here are good things to do. Judge, motion, jurisdiction, those are all standard metadata tags that you can tag up your things.
Yeah, I think that analogy of lawyers as engineers is fantastic. And taking it a little step further, you can imagine that the way that every bridge in the world has been built is slightly different. No two bridges anywhere in the world will be exactly the same because things are different. The environmental conditions are different. The span is different. The weather is different. However, there will be standardized elements of that. The design approach, possibly the style of drawings, possibly the concrete mix, various parts of it will be of a certain standard that the industry as a whole has agreed is the right or best way to do a certain thing. And I think that leap for engineers is very straightforward. They understand the value of standards. It increases safety, it increases quality, and it makes everyone compete on an even playing field. Lawyers just have to get to that same position of understanding, okay, we are all functionally building bridges. How we go about it will be different, and what we end up with can still be unique and bespoke. But some of the steps along the way should be done in a consistent way just for everybody's greater benefit.
Okay, so let's go into question number 3. Damien, you mentioned that one of the areas where we need more standardization is data. Why do we need an industry-wide data standard?
So there's several reasons for data standards, and there's of the 3 examples I had before, there's the data standard, there is the content standard, and then there's the process standard. I think the metadata standard really fuels the other two. And so the ways that, as I share my screen, the ways that metadata helps is to be able to largely collect like with like. That is to be able to say, here are the apples to oranges, right? Let's collect all of the apples. And to the extent that there's a little difference, let's do that as things that are similar but not the same. Let's tag everything up so everything has its own unique identifier. And then you could be able to say, okay, how much, what is the pricing? The benefit is to say, how much does this service is a tag, cost in these matter types? And then what were your outcomes for these things? Did the deal get done? Was there a motion to dismiss? Granted. And then you could be able to say, okay, how do you do, as a lawyer, how do you do this particular doc? Doc is a tag. In this particular jurisdiction, each of those is a metadata tag. Who has done this task? This task is a metadata tag. So you collect like with like. And then you can transfer that data between the stakeholders. You could say, okay, law firms can be able to provide that tagged data to consumers, who can provide that tagged data to vendors, who can provide that tagged data interoperate with courts. And really, there is a interoperability that I mentioned here that if everyone is using a different language between clients, law firms, and vendors, and everyone's saying, okay, we are all have banking law things. If the client is using a different name for banking law, and the firms are using a different name for banking law, and the vendors are using a different name for banking law, you can imagine it's very difficult, if not impossible, and expensive to transfer data amongst them, because you have to constantly map what does the client call banking law, what does the firm call banking law, and what does the vendor call banking law. So within Sally, the idea is that we have an API where we all use the same language. We all use the same unique identifier for banking law, so that you don't have to do that one-to-one mapping. And then for vendors, similarly, all the vendors, there's not just one vendor, but there's many. If all the vendors are similar using the same identifier for banking law, now the data can flow amongst clients and firms and amongst vendors. And as I said earlier, a firm can jump from vendor 1 to vendor 2 because everyone is using the same unique identifier for banking law. So in this way, this is taking out of silos, as Sam mentioned earlier, and moving more toward interoperability to be able to have the data flow amongst each other very easily.
Thank you. Sam, do you want to add anything else to the data standards issue?
Certainly. I think I'll just give a very short example of a real life situation that I was in my previous job working in a law firm, where an existence of a standard really saved the day. We were working on a large property transaction, and as usual, very tight time scale, very challenging budget, all the kind of fun pressures that we usually deal with in legal services. And we had this enormous collection of property documents in the tens of thousands of documents to process and understand. And one of the first things that we needed to understand was, what are the properties? These are all UK properties, registered titles. What are they all? Because we're going to have to order up searches. We're going to have to examine these titles. And thankfully, because the land registry has a standardized schema for what a title looks like, it's 2 letters followed by 6 numbers followed by 2 letters. That may not be exactly correct, but there is a standardized schema. Because that existed, it was relatively simple to build a very small tool that was able to scan through tens of thousands of documents and find all data that matched that particular standard, and pulled them out into a spreadsheet. And then we could assign somebody else the task of go and start ordering searches on all of these titles. Now, if we hadn't been able to do that, then some poor soul would have been one at a time, sequentially, as they came across a title in the documents, taking a note of it and ordering a search. Massively inefficient. We would never have finished on time. A lot of wasted time, a lot of wasted effort. The quality of the work would have been lower. And that approach was only possible because there was a standardized way of describing a registered title. So that example, I think, underlines the power of what Damien was just showing there on screen, to explain that once you have a standard that everyone agrees is how you describe a certain thing, the potential for that to then underpin much, much more important and more progressive technologies really can't be understated.
Indeed. And to follow up on that particular example of real estate documents, within Sally, which I'm showing on my screen right now, we have an asset type that is real estate asset. So you can imagine if you as a law firm and you as a client, that is a corporation, tag up, here is all of my agreements for education real estate assets. Here are all of my laboratory real estate assets. Here are all my warehouse real estate assets. Each of those things has a tag, a unique identifier that is related to it. So you could imagine if I tag these things up within, say, iManage or NetDocuments or some other document management system, now I could say, show me all the student housing titles, and then you could have them in one fell swoop. And then you could be able to say, okay, I've just run that query for student housing real estate assets across iManage. Now I'm also going to run that across NetDocuments. Also going to run that across Docket Alarm. Also going to run that across Thomson Reuters and Lexis. And if everyone is counting student housing as a thing and slapping this unique identifier on that, now you're able to do what Sam described, not just for titles, but all of the documents related to each of these assets.
Very interesting example. Thank you for showing it to us. Are there more like data standards that you think that should be happening? Are there more examples of standardization that you consider to be relevant at the moment?
So I'll speak first about maybe some non-data standardization approaches and leave Damien, who's the expert on the data side, to speak to that side of things. So at Rain and Courts, we have a vision of standardization in terms of approach to product selection, product evaluation, and ultimately product deployment of technology. And without going into too much detail, why we're even looking at it all is recognizing that so much time and energy is spent by organizations, law firms, and law departments on trying to find the right products and evaluate them in a timely fashion and then bring them into the business. It's a very slow process because it's being done from scratch, more or less, every time that we do it. So to give you an example, we have a set of standardized model terms for proof of concepts. And what we do with that project is we go to our customers, who are law firms and law departments, and we go to our vendors, and we say, here's a set of terms that we have come up with collectively together that represent a fairly middle of the road set of terms and conditions that apply to a product being taken through a timed proof of concept process with a customer. Now, those terms won't be entirely what the law firm might like. They won't be entirely what the vendor might like. But we try and strike a balance, and we say to these customers and these vendors in advance, will you sign up to these terms with or without a schedule of exceptions potentially? And having done that work up front, what should happen now is when one of our customers would like to run a proof of concept with one of our vendors, assuming they've all gone through this process, they can just look at the standard terms and agree on a case-by-case basis. Does there need to be any specific exception for this case, or can we just progress and get on with the actual pilot? And we're finding that we're cutting days, weeks, in some cases months out of the process of getting going with a hands-on pilot, because that step is just taken care of much more quickly. And that is a standardized approach using a standardized document as opposed to data terms. And we're seeing the benefit of that now. And we're not the only company out there who are trying to do something to standardize the approach to tech adoption. But so far in its early days at the moment, we're seeing some pretty good results.
Very interesting.
So on my side, my day job is with Fastcase, but I also have a leadership role within SALI, S-A-L-I, the Standards Advancement for the Legal Industry. And I would say that we are getting very heavy adoption across Lexis is a member, Thomson Reuters is a member, we are a member, Rain and Court is a member, and many of the largest law firms, Allen & Overy, Clifford Chance, many of the largest law firms around the world are adopting SALI. And one of the reasons we're adopting it is we are not chasing the things Sam just mentioned. That is the content and process. How do you do the things? Really what we're focused on is what are you calling the things? So for example, as I show my screen, there is a thing called patent law. There we go. So within patent law, we count all of the areas of law. So patent law is a type of intellectual property law. There's a tag for patent law. And so then you could be able to say, so that is the area of law that we're covering. We also say, okay, there's also a service that I provide that is litigation or filing with the Patent and Trademark Office or giving patent advice. Each of these is a service that is going here. And then you could be able to say, for what industry is this service being provided? Is this for the information industry? In particular, is this for an internet data processing and hosting industry? So each of these things is a tag that once you've tagged up that this is a patent law matter, that is a dispute litigation, that is for the internet data and hosting industry, you take each of the unique identifiers, and then you can pull together all of the cases that you have had that is for those particular clients, et cetera. So so that in that idea is being able to say each of these is a tag where you're able to say that this is a patent dispute for the computer and high-tech industry where my client is a defendant. Each of those is a tag that you could then say, okay, show me all of those that Thomson Reuters has, and then run that same query, show me all those that Lexis has, and run that same query, show me all those that Docket Alarm and Fastcase have. So that's really we're counting the metadata. We're not counting how to do a patent litigation. We're not counting the language that is used for patent litigation. That's more in the rating court. They're saying the content and the processes. Merely all we're doing is counting that there is a thing called litigation. And within litigation, there are all sorts of things that happen. There is a pretrial complaint. There's discovery. There's expert practice where you have Daubert motions, you have physical examinations. Each of these we're counting, but not giving any guidance as to how these things are done. But the first step is being able to count that it is being done, and that this is a tag that is worth counting. On the transactional side, you could imagine that there is what are the types of documents that are being filed? What are the types of agreements in the transactional that are being counted? So here are transactional agreements that we've counted thus far. So you could say for a formation agreement, show me all of the contractual clause types in formation agreements. So here you could see draft of about 675 different clause types that we're having, including force majeure is a type of clause type. So if you say, okay, force majeure is a thing that I care about. Once you tag, here are all the force majeure clauses across 100,000 different contracts, and tag it up with this unique identifier. Then you can start doing the content analysis that Sam was talking about. You could be able to say, okay, for force majeure clauses, what language is most common? And then what language is least common? And from there, you could be able to say, okay, you can start going on a de facto data standard on what a motion force majeure clause is. Anyway, so I would say that of the three, that is metadata, content, and process, maybe a foundational is the metadata, to be able to say that a force majeure clause is a thing, tag it up with this. And by tagging up the metadata, you can then better say what is the content that is standardized, and then what is the process to be able to say, here's how you do a force majeure clause in this type of agreement, in a bond agreement, or in a formation agreement, or in a letter of credit, et cetera. So that's how these things work together. It's not in isolation.
Okay, let me add a couple of more examples to the ones you mentioned that might be helpful for the audience. I like very much the One NDA project. I think it's a fantastic example of how a lot of people believing in the same goal from different organizations can work together and get to an agreement in what, let's say, a good example of NDA contract, a contract which is a commodity with which most people don't make much money, but you need to have it. And I think it's a very, very good example. I think now they're working in a second type of agreement. I can't remember that anymore. Maybe somebody in the audience remember, but look at it, One NDA, and it's a fantastic initiative. Some people criticize it. They say the NDA is not good quality. I could do something better. That is not good for all sectors. Okay, I agree, maybe not, but we have a said in Spanish, probably in English as well, which is something like the good is enemy of the best. Meaning that it's better to have something good and not to wait until you have the best. So for me, that's a very, very good example. And also because it shows how competitors can work together and still do business together. I also like that they're going from, let's say, the legal part of the work, and now they are jumping into a technological project, which makes it even more exciting. So for me, as you said, like, hi for this project. I also like the other project, Legal Schema. I'm not sure if I'm pronouncing it correctly. Damien, is legal schema or
Yes,
legal schema, you say in English?
that's right.
Okay. Okay, so that's another project which is also working, concentrated in contracting, and also with the same idea of standardizing clauses and helping we ask to be to agree on things. I think the European Union has done a lot, always concentrating on the languages problem that Europe has. And I think that sometimes we are not, the Europeans, we are not, let's say, aware of the immense and incredible, interesting work that there is there. I think that let's say, the treasure that we have in Europe is not being exploited properly. That's my feeling. I haven't done much research on that, but that's a guess that I have, because for translation purposes, for website purposes, and also for this ambitious project that the European Union has to create high quality legislation, I know that we are very much advanced in Europe, but I haven't really researched much. If somebody in the audience have and wants to share its thoughts on this, it will be great. And the other day I was reading in the MIT Technology Review that I follow, a very interesting news on a guy from Ukraine living in London who had developed a very interesting app in order to help human rights defenders in Ukraine to collect data regarding possible war crimes. And what is interesting is, again, that this is standardization is interesting because, I mean, you can be very nice and take pictures of things, but if these pictures or these records that you collect do not follow the guidelines, the standards of the court, the Hague International Crime Court, then your evidence will serve for nothing. So standardization, I think, can be in so many things. And I think technology is always very much connected. And these are my three examples, and I hope that they are of interest to the audience. And of course, if when we open the question time, you want to add more examples, it will be very interesting to know more. Let's finish with the future. Or you want to add something, Damien?
Just one quick to the. I think the One NDA project is a good example of non-disclosure agreement is a thing that we count on the metadata side. Sally has non-disclosure agreement, and the One NDA project is going to the content, saying, okay, for the thing that is One NDA, this is the content that can be done. And then in the rating court side, you could say, here are the process that is the best practices for the standardized process. So mostly to say that One NDA is addressing this thing and a little bit this thing, and then there's also a standard to be able to say, here's the process. So I would say that that's very important. The other important aspect is that you mentioned other standards, and those don't necessarily conflict with one another, but they are compatible and complementary to one another. So for example, on the Sally side, we count currencies, and we also count locations, and we count all sorts of other things. Where those standards already exist, that is already an ISO standard, 4217. We've essentially just mapped Sally to this ISO standard, saying here are all the currencies. Here are all the industries. For those, we use the NAICS code. Here are all the industries that we go. Here are all the locations. And for location, that is, again, an ISO code. So that they are not competitive. That is, we adopt standards where they exist. And in the same way, there are also legal standards. There's the legal XML. There's LEADS for billing. PACER is the standard for federal courts. UTBMS is the American Bar Association standard to be able to say, here are the types of things that are happening in the UK for litigation, mergers and acquisitions, et cetera. Each of those things can be mapped to one another. That is, you could be able to say, you know, environmental is mapped to this thing that we're doing. At any rate, so I would say that NOS Legal is a separate. NOS Legal is a standard that is being used that is very good. So as I pull up NOS Legal here, NOS Legal is chasing some of the same things that we're chasing. And really, it's just a matter of, if you think of that as a spreadsheet, if you think about how do I implement standards within my organization, You could say, here, this is an example from my company. Here are litigation documents. Here is a complaint. Here is an answer. Here is a motion to dismiss. Each of those is in column H. And then we just map it to this. Here's the Sally identifier for those motions. You could imagine another column saying, here's the column for the raining coat standard, or here's another column for the NOS legal standard. So in that way, you could be able to be compatible with any of the standards. And hopefully there will be fewer standards rather than more standards. That's standards after all should be few. But at any rate, so to be able to map the thing you're counting internally with a standard that is out there is probably the future and the way that you could be able to apply your items.
There is just one more example I'm thinking now, which should be mentioned. I don't know if you know about it, but in Holland, in the Netherlands, they have one set of legislation. It's about some environmental issues, and what this law has done is oblige all. I think it has set an obligation on any municipality, I think it's the municipalities, whenever they publish a legal piece, they have to have a decision tree. And the role of this obligation is to help standardization and to facilitate the implementation of technology. And I think it's an incredible example of how things could be done in the future, because if you create a law and within the law you impose or you create the decision tree regarding the law as an annex, then you are already facilitating developers the work to create the workflows for automation of that law. I don't know if I explained myself correctly because I was improvising a little bit. Do you know, maybe Sam, you know more about this Dutch legislation?
So not specifically that legislation,
Okay.
but I think I understand what you're talking about. You've reminded me of a big part of the process for document automation. It's very similar. And in my previous career, I spent a lot of time working with fee earners who automate standardizing of documents. And when you were sketching out a decision tree for a contract in terms of what are the variables, what are the data points you might say in this contract, and where are the decision points, and if I require version X of a clause versus version Y, with implications of that mapping process, that kind of bottom to top mapping process, it would often reveal some fascinating inefficiencies or dead ends or strange loops in the logic of how your document was intended to function that are very hard to understand just from the face of the document. And I believe that's quite similar to what you're describing in terms of helping the reader of the document understand the logical flow through the process to get to the desired outcome. And document automation is a topic we could talk about some other time, of course, but that's core to how that works. And it's standardization there, not necessarily in terms of the variables and the data points, although that is definitely valuable, but it's also a standardization in terms of the thought process, the logic you apply. And if you are a computer scientist, you might think of it as, say, pseudocode, where you're not looking at a specific programming language, you're looking at an abbreviated, truncated form of thinking that just tries to describe at a higher level what's actually happening with a logical flow of data through this argument. And I think that's a massively valuable skill that, unfortunately, our profession is generally quite lacking in.
Yeah, I fully agree. It's like expert systems, but the thing is that I believe that a legislation should include like an annex with, let's say, the instructions for expert systems development. It will be so helpful, that will be really something interesting for the sector. Okay, let's then talk about the future. How should be the future regarding standardization? Where should legislators or maybe vendors or other operators who have a role in the field of standardization, where should be putting their energy? How do you see the future?
I guess I could maybe start with that. So the future, I think, is having agreeing upon what standards are going to be used for what types of documents. That is, perhaps I will use, this metadata standard or this content standard or this process standard. So between those three, being able to, step one is to be able to figure out a metadata standard to collect like with like, that is collect all the merger agreements and force majeure clauses. And tagging that up is not that hard of a process. That is, the metadata is relatively straightforward. I've worked a lot with lots of vendors and lots of law firms who have said, how do I do this? And it's largely just taking a spreadsheet, much like I showed just a moment ago, and being able to go row for row and be able to say, we call this thing X, and you call this thing maybe something a little bit different, but here are the commonalities. And to the extent that we don't count something that they count, perhaps we will add it to our data set. That is, we will add it to the types of services that we provide, et cetera. So what kind of advice we give, et cetera. So I think that being able to do that mapping, like you see here, is probably the future, and that's actually the present, right? But then being able to say, okay, now that we've collected all of the motions to approve compromise, filed in this court before this judge, I think the next is the fun part, because what that gets you is to be able to say things like you see on your screen here. You could, when I was a lawyer, these are all things that matter. So these are all metadata tags that are in the Sally data set. So a complaint is a thing, an answer is a thing, a motion for summary judgment is a thing, an order granting motion for summary judgment is a thing. So you could think as a lawyer, I litigated for 15 years. My clients would say to me, Damien, what are the odds of winning a motion for summary judgment? And I would say the odds are, in my 15 years of practice, pretty good or not bad. But if you have metadata tags for that, you could be able to say the odds in federal courts in the United States are 54%. And they could say, Damien, we're in the Minnesota District Court. And I could say, well, in the Minnesota District Court, it's 45%. They could say, but Damien, this is in front of Judge Susan Richard Nelson. You could say, okay, that jumps up to 58%. They could say, but Damien, this is a trademark case. And I could say, well, actually, for trademark cases, it drops way down to 37%. Each of these things is a Sally tag. This kind of calculation would be impossible if we did not tag up federal courts as a thing, Minnesota District Court as a thing, judge as a thing, and trademark as a thing. Only by tagging them up with this metadata can you get the answers that you see here. And then you can run all sorts of other analytics once you've tagged them up with the thing. So you can see here that this isn't telling me how to draft a motion to dismiss yet, right? It's just telling me percentages of things that are granted for these judges in these areas. But now I can say, okay, show me all of the Susan Richard Nelson motions for summary judgment that she has granted. And now I'm going to get 68 or so, 67 results. You can imagine taking each of these documents that you see on your screen and running a textual analysis to be able to see what arguments and cases are more statistically likely to win for this judge, for this motion, for this trademark cause of action. Then you get to the content side. Once you do the metadata side, you could be able to get content to be able to say, yes, these are the things that matter. So anyway, so that's, I think the future is tagging things up with all of the tags that you see here. We have 10,000 of them. The odds are, if you're counting something that matters, we have them in our 10,000. And then after you do that, then do the analytics on the thing. What is the percentage granted, denied, and then do the textual analysis to be able to say, show me all the things that win. I think that's the future.
Mm-hmm.
Sam, how do you see the future?
I think what Damien's been showing there is data-driven decision making. I think that is the future. And I'll give you another little story example from my past life in private practice to underline what I mean by data-driven decision making. In this context, it was a construction project. I was a construction lawyer before working in innovation, and we had a client who was building a hotel. And we worked with this client many, many times. And the client came in with their documents and said, hey, here's the professional team who are going to build this hotel. Here's the architect, here's the structural engineer, here's the mechanical engineer. And the law firm is then looking at that, and the partner in charge of that team is trying to estimate the costs, the budget estimate for the client. And he says, okay, that architect there, they are difficult to work with. So I'm going to add, say, 20% more time to the budget to work with that. And when I questioned that, because I was a young green lawyer, I just said, how do you know that's 20%? And the partner said, I just do. So because I couldn't let that lie, I went into our document systems and began to look up all the previous contracts with that architect, and then manually working out the editing time from metadata in the documents, the version control numbers, and then doing a comparison against other architects for a control sample. And working through that, I came back and realized that the partner is partially correct in that it genuinely does take more time to get that architect into contract, but it's not 20%, it's 50%. So going back to the partner, I was able to show the data and say, I think we should actually add more to the quotation for this context. And the partner said, that would have been very helpful 2 days ago when I gave the client the cost estimates. And the reality is that process could not be done consistently every time we've got a question like that. However, if the contracts, the underlying documents had standardization in the way that Damien's been showing on the screen, if we had the entities tagged correctly, if we had the context tagged correctly, that it's a hotel, that this is the architect, that it's in Scotland, that it's over X million pounds of a project, if that data had been there and queryable, we could have validated or challenged that assumption in seconds, as opposed to, in my case, an afternoon of digging through documents. And why would that have mattered? Well, it would have mattered to the law firm because we could more confidently estimate the cost of this transaction. It would have mattered to the client because we could give them a much more bespoke and accurate cost assessment, and ultimately probably a more accurate bill at the end of the day. And it would have also helped the lawyers, the individual lawyers working on the case, because they could allocate their time accordingly. Everybody would benefit from that data-driven decision making. So for me, that is the future. But for that future to happen, we have to agree on what the data actually is. And for that to happen, we have to agree on how we describe the data, which is standardization.
100%. And the 20% that I love that story, Sam. The 20% that your partner gave, there's a name for that, and it's called anecdata, right? Also known as a hunch. This is a hunch that partner had. And Sam was able to demonstrate through real data, not anecdata, not a hunch, but real data. And I think that data-driven decision-making is not just the future, but it's the present. Many law firms are doing this today. And I would argue if you're not doing data-driven decision-making, like I showed on my screen earlier, you're behind the times. And there is a question that if I say, like most lawyers say, the odds are pretty good and not bad, if you have these tools available to you, is that maybe soon going to be malpractice? That is, if there's a 1 in 3 chance of winning, and I say it's a pretty good chance, and the client spends $15,000 on this thing, would they have spent that $15,000 for that motion if they'd known that the odds were only 1 in 3? Am I doing an ethical disservice by not giving them the 1 in 3 chance rather than a pretty good chance? So this goes to ethical and what we were talking about earlier. What's good for society? What's good for your clients?
Guys, I'm a little bit worried, and I want to pose you a question. If the future is data-driven, and if the initiatives to standardize data are happening only in certain places, like, for instance, your initiative, which is English-speaking and concentrated in the Anglo-Saxon world, will that mean that the Anglo-Saxon world will have a competitive advantage compared to, for instance, the Spanish-speaking world? Because that's something that really worries me. How do you see that? I mean, and also with other languages. I'm talking about Spain or Spanish because it's my language, but Dutch, German, France, or French, Italian. How do you see this?
I think that the things that we count as lawyers are cross-jurisdictional. That is, so I'm going to share my screen again. We've shown the Sally project to German lawyers. We've shown the project to, as we share here, we've shown the Sally project to UK lawyers. We've shown the project to Australian lawyers, again, largely English-speaking. But you can imagine, for the criminal law and for the particular criminal services, what are the types of criminal things that happen? That is not limited to one particular jurisdiction, but if we have, for example, crimes against property, so arson, criminal theft, criminal trespass, each of these things I think that is in Spain, right? It is in Germany, right? Crimes against the government, bribery, counterfeiting, illegal reentry, insurrection. Really, all you need to do in the taxonomy ontology is we could say, what's the alternative label? In French, it's this thing. In Spanish, it's this thing. The most important thing is that it has a unique identifier. That is, in Spanish, crime against the government has this thing, or bribery has this thing. And so the unique identifier is the thing that is counted. What language you use for bribery doesn't matter. You can say that in Spanish. You can say that in German. You can say that in Swahili. The thing that matters is the unique identifier. That make sense?
Yeah, well, it makes sense, but indeed, I think it means that everything is in English, and there is competitive advantage for Anglo-Saxon the Anglo-Saxon industry, and I think we should be thinking of creating something similar or working with you and developing our own language standards.
I would love to work with so Sally, because it's being adopted worldwide. I would love to be able to, creating multiple standards just creates headaches for everyone, because then they, do you go with the Spanish focused standard versus the UK standard versus the German standard versus the Italian standard, right? So I would say that what I just described and what I just showed on the screen, saying for bribery, right? Here is the Spanish version of bribery. Here's how you say that in Spanish. You could have the name, whatever the name is, and then you could essentially be able to say, okay, if you're a Spanish person, you could run this same query across Thomson Reuters and English speaking as you can with Spanish speaking. So I would say that being able to essentially augment the thing that is already there with the language, whatever the word is probably the right way to go rather than creating your own. Because like I said, we have 10,000 things that we're counting already. There's no sense you recreating the wheel.
Yeah.
And we would love to be able to.
This is probably a project for a university to adapt it to Spanish. Yeah, and now we have European funds here in Spain. Maybe it's a good moment to try it. Let's go and ask the audience if they want to intervene and ask things or comment. And then at the very end, Damien and Sam, I'm going to ask you to do the closure with a final sentence summarizing your ideas. So please, Marilena, can you please moderate the audience now?
I'm seeing Christoph.
Yes.
Go ahead.
Many thanks to both of you. Thank you, Daniel. Thank you, Sam. Your contributions were really valuable, and I'm sure that our audience has also enjoyed them a lot. And yes, do you have any questions? If you prefer, you can take the microphone directly, or you can write in the chat if you feel more comfortable.
It looks like Krista in the chat, Christoph Kung already asked a question. And so I'll summarize that question saying, one NDA is great. And he's saying from a technological perspective, wouldn't it be better to collect the data for NDAs, aggregate it into a smart contract to reflect the most used clauses in that contract? And so really what he's describing is using metadata, saying NDA is a thing. And then a particular clause, force majeure, in the NDA is a thing. And then be able to collect from a bottom-up way, saying, show me all the force majeure clauses in an NDA, and then essentially use that to build the content of that. And I would say, yes, first step one is to be able to agree that NDA is a thing. Step two is to be able to agree that a clause within the force majeure clause is a thing, and then be able to collect that standard language to be able to say, here are the most common clauses for that. And then he responded, so anyway, so I guess maybe that's step one. Sam, other thoughts on what I just described and what Sam, Christoph is asking?
Yeah, certainly. So something that I think a lot of us would love to see one day is some kind of automated contracting process where you may, for example, adjust sliders or pick from a menu what your acceptable positions are. The other part is the same thing, and then automatically a common ground is found and your contract is executed. Very, very powerful vision. And I think at some point in the near future, we will start to see, probably based on smart contract technology, that coming through for a variety of non-complex consumer contracts. Some kinds of insurance contracts would be the most obvious candidates. And the potential there is enormous. And I think one NDA might be the tip of the iceberg there. And the way their project generally works it's intended that you don't negotiate. That's the point. However,
Yeah.
it's not a big step from there to say, okay, here are 3 negotiable points, and each point comes in so many different flavors. Which ones would you accept? And part of the analogy I occasionally use is, in the modern day with everybody working remotely, using a tool like, say, Calendly to try and pick mutually acceptable times for a meeting. That concept, I think, will soon be applied to various contracting approaches, such that you just choose what is okay for you and a middle ground is found. And that is also underpinned by standardization and by schemas to understand what are those contractual points and what are the possible stakes they could be in.
I 100% agree with that. And that's there was an idea with web browsing and privacy a few years ago that Microsoft rolled out to say, I as a consumer, I as a browser, here are the privacy things that I am comfortable with. And that was a standard that was supposed to have, at the time, Internet Explorer and Firefox and all of the other browsers would say, I'm going to respect your privacy and be able to essentially have all of the websites be able to respect the privacy that I've laid out. Sadly, that fell away, but I think what Sam said for the contracting is absolutely right. Here are all the positions that I as a company am comfortable with, and then we'll mash those and mesh those with yours, and we'll just argue about the stuff that really matters and not about the stuff that doesn't.
Thank you, Maria. Thank you, Sam. Thank you, Damien, for answering my question. The second one, and this is kind of a follower, is really how to collect real client data and exchange and use it in order to aggregate it in a smart contract. And I don't have a solution for this because law firms are typically not allowed to exchange and share data. What's the solution here? Do you have any idea?
My thought is it depends on your data set. Is it a public data set or is it a private data set? So for example, in my company collects public data, that is litigation data. It collects regulations and laws, statutes. Each of these is a public data set that I don't have to worry about client confidentiality. So if you have a public data set, you can collect like with like. What are the most common motions in front of this judge? And what is the most common language used for those motions? That is a public thing that you don't need to worry about. The private data set is more difficult, as you mentioned, because there's the attorney-client privilege and there's all sorts of other client confidentiality. Some ways that you might consider doing it is at the service vendor level. That is the document management services. I manage NetDocuments and the other document management services. Perhaps they could extract across their entire data set all the force majeure clauses, not attributing it to any particular client, but they can anonymize and aggregate and say, here are the most common force majeure clause languages for mergers and acquisitions agreements or for foundation agreements or whatever the agreement is. So that way you're not disclosing any particular client's thing, but you're able to do it in the aggregate. But I bet Sam has better ideas than that.
Not necessarily better, no. The question reminds me of a conversation I had with a friend of mine who's a data scientist recently, and he said that 80% of his job is cleaning up poor data and 20% is doing clever things with it. And I think in terms of private data sets inside law firms, I'm not sure we can escape the fact that someone's going to have to do a tremendous amount of dirty work cleaning up historical data. And there are some approaches with automation and natural language processing that can help. But from my perspective, those tools, their accuracy rate just isn't quite there yet to make a complete contribution, although there is a start at least. But ultimately, we are going to need human beings with the right skill sets to retrospectively go through private data sets and tag them up accordingly. And that is going to be a thankless task for some people to do, but it needs to be done. And personally, I'm not convinced that the AI technologies available right now or in the next 10 years will be able to do that to a satisfactory level. I think it needs to be a manual task and it needs data scientists to understand the terminology to do it. And that's going to create a significant demand for those skills in the next 10, 20 years.
I agree with that, and I work with data scientists every day, and we essentially data science uses the terms precision and recall. Precision is being able to make sure that the thing that you've classified is accurate, and then recall is making sure that you've gathered all the things that are there and you haven't missed anything. So on the precision of recall, getting precision is very hard, and getting recall is very hard. And often you have to balance, how much of a threshold do I want to have less precise, that is some errors but I collect more of the things, or do I want almost no errors and then I gather fewer of the things? So you have to really be able to balance precision and recall. So I agree that with Sam, that to be able to have that balance, you need humans that are subject matter experts. That is, you need lawyers and you need programmers, and perhaps both lawyer programmers together, the same person. To be able to do this work. I'm a lawyer programmer. Two of the other people on my team are lawyer programmers. So I think that we can move more quickly because we can say, yes, there's not the explanation that I have to say to my data scientist saying this is how the law works, because the data scientist is a lawyer. So they know exactly how these things work. So I would say for anyone who is teaching and they have students who are considering, who are technologically savvy, perhaps they were coders in the past and are going to law school today, we need both of those in the same person to be able to do the work that Sam just described, to be able to convert the language of the law into code.
Okay, guys, I think that we probably have to stop now. If you want to give us your final sentence, that will be the closure of today's event.
Sure, I'm happy to go first. So my final thoughts for the day is that, to quote the former president of the Law Society of England and Wales, if you get replaced by a machine, you deserved to. And I always keep that in mind when I'm talking about automation and data. And I teach that to my students to say, look, you can add tremendous value as a provider of legal services if you focus your efforts on the right things. You put your time in the face-to-face customer service. Let technology do the parts of your services that they should be able to do. And don't be afraid of that. See it's an opportunity to spend more time doing the truly valuable stuff. And for that future to exist, we need data structures, we need standardization. So my advice to anybody in this field is not to see this as a threat, but as an opportunity, and try your best to get involved where you can, because the future is extremely bright.
I would agree with that 100%. That is absolutely well said. And I would say that I would agree with that. And to add that standardization is not eating lawyers' jobs. That is being able to count all of the motions, or be able to count all the merger agreements, and being able to count all of the force majeure clauses, and to be able to count all the jurisdictions. That's not something that we went to law school for. That is stuff that is below us, I would argue. And so, to Sam's previous example about the lawyer that said it's 20%, right? Without really having any data to back that up. Really, standardization and being able to tag the things that matter is not a lawyer's job, but it can help a lawyer's job. That is, once you standardize on here are the things that matter, here are the data analytics that come from the things that matter, here's the most common language for these clauses. These are things that will make technology like an Iron Man exoskeleton for our lawyers. That standardization will allow me to be able to focus on truly counseling. In the English term, that lawyers are counselors. Machines are not going to be able to counsel. Machines can count things really well. It can count all the force majeure clauses. It can count the agreements, but it cannot counsel. Let's leave to the machines what is machine-like, standardization data, and leave to the lawyers what is best for humans.
Thank you, Damian. Thank you, Sam. Thank you, dear audience. And see you on 11th May when we will be discussing lawyers' profile that law firms are looking for. That's our next topic. So I hope to see you then. And we will be posting soon the video and the infographic resulting from this super interesting session. Thank you so much. Have a very nice rest of the day. Bye-bye.
Thanks, everyone.
Thank you, everyone.